Listen to a finished, polished music track playing through your speakers. You are hearing a final product, delivered straight to an audience. It is common to assume that the person who wrote the lyrics and composed the melody simply owns the song. That ownership is established through copyright. But consider the other people involved in making that track a reality. Who protects the lead singer who actually performed those lyrics? Or the studio that bought the microphones and paid for the session? What about the network broadcasting it to your radio? Copyright strictly protects the author of the underlying composition. If that were the only legal tool available, all those other contributors would earn absolutely nothing from their work. That gap is filled by a parallel legal framework known as related rights, or droits, voisins in Belgium. These laws are designed specifically to protect the non-authors who bring the creative work to the public. Every time you press play, you are navigating multiple, distinct legal frameworks operating all at the exact same time. Let's strip a track to its core. This glowing center is the underlying melody and lyrics, protected purely by traditional copyright. Now wrap around that core. This first outer layer represents the artist-performer, the singers, actors, and dancers who bring it to life. Performers receive their own set of economic rights. This gives them legal control over the reproduction and distribution of their specific vocal or instrumental recording. They also receive moral rights. This grants the performer the inalienable power to have their name credited on the track and to protect their performance from being distorted or misrepresented. For performances fixed onto a physical or digital audio recording, a phonogram, this legal shield lasts exactly 70 years. The performer's right does not reward the invention of an idea. It rewards the unique human act of expressing it. Expanding outward one more step, we hit the second outer layer, the producer. This represents the studio machinery, the organizers, and the financial backers. Producers are neither authors nor performers, but they take on the critical financial risk required to fix that sound onto a master recording. Because their contribution is financial rather than artistic, producers receive only economic rights to help them recoup their investment. They receive zero moral rights. Publishers and broadcasting organizations also hold similar related rights, protecting the immense logistical work of transmitting media across networks. As we move outward from the song's core, the focus of the law shifts. It stops rewarding creative expression and starts protecting the logistics and capital required to distribute it. All of these layers collapse back into a single, unified item. They exist perfectly superimposed on the record playing on your turntable or the files streaming on your phone. A clear rule of music licensing emerges from this structure. To legally exploit a track, you must simultaneously satisfy the author's copyright, the performer's related right, and the producer's related right. Today, a musician producing tracks in their bedroom can act as the author, the performer, and the producer all at once. Even when one person performs all those roles, the law and the tax code still separate their income streams into these distinct legal buckets. Understanding a creative work requires seeing past the audio itself. You have to recognize the invisible architecture of rights, ensuring that every contributor gets paid for their specific role. Before we conclude, a brief legal note. Navigating the layers of creative law is complex. The concepts discussed in this video are provided for informational and educational purposes only, to help you understand the landscape of related rights. It does not constitute formal legal advice. Always consult a legal professional for your specific situation.